Hi, everyone who's joining. We'll get started in just a few moments. All right, so I'm going to go ahead and start. Welcome everyone to tonight's Parent and Caregiver Speaker Series. Tonight we are hosting a presentation regarding guardianship and alternatives to guardianship. And tonight our speaker is Victoria Sulerzyski. Before we get started, I wanted to introduce myself and talk briefly about the Down Syndrome Network of Montgomery County. We are the Down Syndrome Network of Montgomery County, and our mission is to support individuals with Down syndrome. And we are hosting this series in order to bring you information regarding pertinent topics. So just a couple housekeeping notes. So during the presentation, we would ask that you keep your microphones off. If you could mute yourself at this point, that would be great. We're going to save all of the questions towards the end, but you are welcome to put them in the chat box. Or when we get to the question section, to raise your hand, and we'll make sure that Victoria is able to respond. Everyone should be choosing whether they would like to hear this presentation in English or Spanish. At the bottom of your screen, you'll see a little icon that looks like a globe, and from there you can select English or Spanish. If you need closed captioning, there's a live transcript at the bottom, and then you can choose to show the subtitles in English. We are recording this webinar, so please note that. And then also too, at the end of the presentation, we're gonna send you a link for a survey. We'd ask for your feedback on that. It'll just help us as we plan future events. Speaking of future events, here's a couple that we've got coming up. So I'm not going to read these out to you, but just take a look at some of the events that DSNMC is going to be hosting during early March. And we would just invite you to follow us either online. You can sign up for a newsletter, or we're on all of the different social media platforms. I think minus TikTok, if you would like to stay up to date on some of the events that we're doing. And then I'm going to let Victoria introduce herself briefly. But I would just like everyone to please, at this point, make sure you're muted. And once again, questions can head towards the chat. My name is Jen Emmel, and I am the Transition Youth and Adult Program Manager for DSNMC. And tonight I'm going to be hosting, for the first time since 2018, a Zoom meeting. So please bear with me, because I'm trying to learn as we go. So at this point, I would like to turn it over to Victoria and allow you to introduce yourself for a moment and then get started on tonight's presentation.
Thanks, Jen, and thanks everybody for joining. I'm really pleased to be here tonight. I'm an attorney. I'm also a mother of a multi-disabled, medically fragile daughter. Been through transition already. I have over 20 years of experience in estates and trusts and special needs planning. I also do a lot of guardianship work and counsel individuals and families regarding means-tested government benefits, doing special needs planning, which would be special needs trust, first party special needs trust, third party special needs trust, advised on pooled income trust, ABLE accounts, all the government benefits. We do a lot of counseling in our office with families and help them navigate the maze of post-second education. So tonight, though, we're here to talk about guardianship and what are the alternatives to guardianship in Maryland. Next slide. I'd like to go ahead and thank everybody, Matthew Mullen and Jen, for having me here tonight. Next slide. And this is the dreaded legal disclaimer. This presentation is not intended to be legal advice. There's no client attorney privilege during this presentation. I often say, if you have a question or need legal advice, please seek out an attorney that is, has a concentration in special needs planning and guardianship work. This lovely lady is our daughter, Abigail. She's 25 years old, soon to be 26, and she lives out in the community with a roommate right around the corner from us in her own home. And she thinks she is it, because she is, and she brings a lot of joy to our house, to our hearts and to our family. Next slide. So let's get started. The age of majority in Maryland is 18. So what does that mean? It means that every individual has the legal capacity to make decisions about their adult living, financial decisions, legal decisions, healthcare decisions, until that competency is rebutted in a court proceeding. HIPAA, which is the federal healthcare privacy law, says that if you're an adult and you're competent, you have control over your healthcare, and unless you waive that control or waive the presence and give permission, and can legally give permission to the individual to waive the presumption that, or consent that someone else can be with them or step into their shoes to make decisions for their healthcare, you're not going to get through what I call is the HIPAA gate. So I know that when I was young, when I was coming up with Abby transitioning, we kind of hit this very early on. Some of my clients don't ever hit it until much later in life. Others do get, hit the HIPAA gate, so to speak, earlier in the adult world of their disabled child. So we'll talk more about what that means, what are the alternatives, and what also is the path of being least restrictive to the most restrictive, which is what we're going to talk about tonight. Next slide. So what's capacity? Capacity is circumstantial. It's specific, and everybody's different. It's the individual is able to understand and communicate what choices he or she is making, understand what the alternatives to those choices are, and the consequences of their choices. There's a legal, social, and societal presumption of competency in adulthood. Physician certificates are very helpful. If an individual may be capable of going ahead and being able to understand legal documents, my office will not prepare advanced directives and powers of attorneys unless a physician provides the ability to say, yes, that this individual is competent to make legal decisions. In Maryland, you need one physician to say that you are legally competent, but you need two medical professionals to say that you are not competent. And we'll get into that very shortly. Next slide. Like I said, there's a continuum of capacity, the more capable to the less capable. And keep this continuum in mind, because this is very important in Maryland, because the alternatives to guardianship are where the individual is more capable, and then guardianship, which is the most restrictive, is when the individual is less capable. So when we're talking about this concept of guardianship and guardianship alternatives, keep this continuum capacity in your mind. Next slide. If the individual is capable of making voluntarily an independent and knowing decision about whom they want to select to assist them with their healthcare decision making, then least restrictive methods should be used. We are going to review from the least restrictive to the most restrictive in this discussion tonight. Next slide. Okay, healthcare decision making with capacity. So if a loved one is capable of making decisions regarding their healthcare, that's going to provide them, excuse me, with the ability to consent or withhold consent for their medical care. They're going to have the ability to employ and discharge healthcare providers, make discharge, transfer, and their decisions on their own healthcare, and to consent to either provide the care or withdraw the care. This would also include their ability to consent or withdraw life-sustaining procedures at end-of-life decision-making. Next slide. One of the least restrictive on the ability to have on the continuum to have the capacity to actually make decisions is an advance directive for healthcare. This document appoints agents to act when an individual is incapable of making decisions for themselves due to the lack of capacity regarding their healthcare. It may include very specific instructions on what the individual wants for their healthcare, particularly at the end of life stage, where they may be in a coma, unable to recover from that coma, and there's no hope of recovering. And what do they want those end of life decisions to be? The individual will be able to engage with their healthcare team in making important decisions in an adult fashion, planning for their future, and making meaningful appointments with their doctors, be completely control with their healthcare decision making, and be able to communicate that effectively to an agent to act when they're not able to. An advance directive is also flexible. It can be changed. And by doing that, it overrides the previous advance directive and making that previous advance directive null and void. An advance directive can be effective upon signing it, and it also can be, or it can be effective upon two doctors certifying that the individual is not capable of making healthcare decisions for themselves. There's pros and cons to both methods. We typically recommend an advance directive is effective upon signing the document and securing the document in a safe place, because there's lots of reasons why you would not be able to get the two-doctor certification if you become very ill. Next slide. When there's no capacity or diminished capacity to execute legal documents, we are moving down that line of least restrictive to most restrictive. So the next would be surrogate decision making. Surrogate decision making in Maryland is dictated through a statute. In Maryland law, there is an order of individuals that can serve as a surrogate for an individual that lacks the capacity to have signed an advance directive. The surrogate decision making is where the individual who is acting as a surrogate knows and understands the level of health care and how the health care is to be given to the individual that lacks capacity, and does not substitute his or her own beliefs onto the individual who lacks the capacity, and make those decisions not of how they would act, but how the individual that lacks the capacity would want and has been able to express that to the surrogate that is acting on behalf of them. Supported decision making is rather new in Maryland. this is where the supported decision maker is an individual who does know the capacity, the lack of capacity, the individual that does not have the capacities, wishes, and that individual is providing an affidavit. So it's the supported decision maker who is the one that is saying in an affidavit, yes, I am willing to serve as the surrogate decision-making person for this individual. This individual and I have discussed, or the individual lacking capacity has made it clear of their decisions of how they want their health care to go, and particularly during the end of life decision-making times. That affidavit is then presented to a medical team or a medical doctor at the time that the supported decision-making needs to happen. So the least restrictive is advanced directives and healthcare powers of attorneys. And then we go to surrogate decision-making in the continuum. Then we go to supported decision-making. We also have another document here in Maryland called Medical Orders for Life-Sustaining Treatment, or we call it MOLST. I've, in the presentation, given you a link to marylandmolst.org. This document basically says what your wishes are of how you want to treat CPR and any other type of an emergency type of situation. This is a decision that you should be talking to the doctors if you have the capacity to. So the doctor actually completes a MOLST form, and the MOLST form is given to an individual, typically the 911 CMT paramedics, and then also the emergency room doctors. It's different than an advanced directive, but it also states certain wishes individuals have regarding life-saving type of measures like CPR. Next slide. So I've just basically described what surrogate decision-making is. It's used in order for it to be a lesser restriction to the most restrictive, which is the guardianship proceeding. Next slide. This is the order for surrogate decision-making in Maryland law. Wow. A guardian for the patient, if one has been appointed, the patient's spouse or domestic partner, an adult child of the patient, a parent of the patient, a brother or sister who's an adult, or a friend or a relative that meets certain requirements, which we will get to in a minute. I think when people look at this particular statute, and particularly for individuals who are transitioning youths, parents down, it's kind of surprising. Parents is number 4. And guardians number 1. So it's, to me, when I first read this law many whiles ago, I was like, I was expecting a parent to be a little bit higher. But I can understand now the pecking order here kind of makes sense when you sit back and you think about it, because the guardianship rules and the capacity rules are from 18 years of age all the way through, the longest living person ever. And when you look at it through those lens, this pecking order does make sense. Next slide. A friend or other relative that's in the last slot in the pecking order has a little couple more hoops to jump through as a surrogate. They have to make sure that, one, they're a competent individual themselves, and then they present the affidavit that I was discussing to the attending physician that says that the person is a relative or close friend of theirs, and the specific facts and circumstances that demonstrate that they have an understanding of the healthcare decision-making that the individual that they are acting on behalf has been able to express to them. And that's the little extra that they have to do, whereas a parent or an adult child or a guardian or a spouse does not have to have that affidavit. So it's a little bit extra step. Next slide. So supported decision-making, as I said earlier, enables individuals to make, communicate, and effectuate decisions about their healthcare. And it's usually an individual that they have a lot of trust in. It's a person-centered structured framework. And also the decision maker is the individual that has the disability. Supporters help. They don't decide, and it gives validity to the decisions made in this context. So it's rather new in Maryland, but it's an exciting alternative to guardianship. Again, I want to say that my experience with the reality of the surrogate decision making and supported decision making here in Maryland is been mixed in reality. Some parents have reported that they don't have any issues with medical decision for their adult child that have disabilities, and others do run into some issues. So the less restrictive forms and the alternatives to guardianship, if we can use them, that's the first way that it should be implemented. And there are some individuals who just cannot be able to avail themselves to the alternative methods because of the ability to express their beliefs and their wishes with their health care. Next slide, please. One way of, a person can definitely, if they are able, is you could go to the doctors with your child, and if your child is capable of saying, I want my mom or my dad or to be in the room and consent for me, that's golden, right? Consent is always the least restrictive. They may also go ahead and say, I want them to act on my behalf, or I know that sometimes if you have an individual who is nonverbal, if they point to someone or take someone's hands, that could be another nonverbal way of consenting. I also encourage you to meet with your child's medical staff in advance of the 18th birthday to plan for some type of future decision making. That can be very helpful. Again, when you as a parent continue to have the ability to make decisions regarding your child's health care until they turn 18. Once they turn 18, that ability switches to them. And again, where we started at the beginning of the presentation, under Maryland law, every adult starting at 18 years of age, which is our age of majority, is competent until a court of law states that they are not competent. So I encourage you to have conversations with your pediatrician or your general practitioner about this right around the 18th birthday, so you can get an understanding of what they believe your child can and cannot do. Next slide. So we're to the most restrictive form for healthcare here in Maryland and for finances, and that's guardianship. So guardianship is a legal and judicial process to determine whether someone is not capable of making certain decisions. And it's appropriate for the court to appoint someone to do so. So there is a burden of proof in a guardianship matter. A disabled person is defined as an individual who's been judged by a court of law to be unable to provide for daily needs and or management of his or her property. Guardianship creates a long-term relationship with the court. A guardian of the person or a guardianship of the property is actually an officer of the court. The court is the ultimate guardian of an individual who has been deemed to be incapable of making decisions for themselves, for healthcare, and for their financial assets, and it can take away some rights of the individual, not all. It's public record, so someone can see the court case on Maryland Case Search. And it is expensive compared to other options. A guardianship proceeding has a order to it, which we will discuss, and it truly is a process. It takes several months to get a guardianship in place in Maryland. There is an exception for an emergency guardianship, but it is based on a medical procedure that is life-threatening, that the court has to intervene immediately in order for that procedure to move forward. Next slide. When is guardianship necessary? When the lesser restrictive alternatives are not available, when the child is 18 years of age or over, and there is an exception if the child is under 18 and the natural parents both die, then a guardianship of the person and or property may be required. Next slide. So what's the process? First of all, where the child lives, what county or city, Baltimore, will determine where the guardianship proceeding is going to be filed. You file a petition for guardianship. A petition for guardianship is going to basically adver, meaning it's going to state to the court why this individual needs a guardian of the person and or property. We will need to get certificates. There'll be a service of everything on interested persons. There'll be notice to interested persons. The court will issue a show cause order. They will issue an order appointing court-appointed counsel. There'll be a hearing. There's pre-hearing orientation and post-hearing training and annual reports. So that's a summary of the guardianship process. Next slide. So petitioning for the guardianship, like I said, it's going to be filed in the county or Baltimore City that the disabled individual is domiciled in. So for instance, we live in Anne Arundel County. When we went to get guardianship for our daughter, we filed in the circuit court for Anne Arundel County. In the petition for guardianship, it's very important to have very specific facts to support the petition. And the facts I typically are centered around very specific type of situations. So for instance, when I'm drafting a petition for guardianship, I ask the moms and dads that are petitioning, can you please provide examples of what your child cannot do centered around healthcare, community, self-help skills, emergencies. Do they understand what 911 is if a fire broke out? Would they be able to exit the home safely? Can they cook independently? Can they use a stove? Can they use an oven? Microwave? Do they make sandwiches for themselves? Can they, are they potty trained? Can they go ahead and use, without any support, use the bathroom facilities? Can they brush their teeth independently? Can they shower by themselves? Can they appropriately pick out their clothes and get dressed? What about when they go in the community? Do they have the capacity to understand who might be a danger to them? I often call it the puppy dog syndrome. If an individual pulls up in a car and says, oh, please come see my puppy dog. He's so super cute. Will they get in the car if they're out and about on their own? Can they navigate the community? Is there a fear of flight? Is there a fear that they'll run out into the road without looking both ways? These are the different things that I want to make sure we are putting in our petition, so we're making sure the judge understands that that this individual needs assistance in order for them to remain safely in the community. Excuse me, Kate. who are the parties of the petition? It's going to be the individuals who are seeking to be the actual guardians. You can have co-guardians. Some of the courts in Maryland really would prefer if one person serves as guardians. Some will expect a compelling reason for two guardians to serve together. Montgomery County, in my experience, has had no issues with having co-guardians. You will have interested persons that the petition and supporting documentation needs to be served on. And then the court-appointed counsel will be appointed by the court. Their role is to represent the alleged disabled person and report back to the court on whether or not that individual does need a guardian of the person and or property. Next slide. So what's the documentation we need to go along with the petition? It's going to be certificates. So in Maryland, like I said earlier, you need two medical professionals to state that an individual is incapable of making decisions for themselves for healthcare and or for their property. The key here is timing. The two certificates, one has to be a physician who examines the alleged disabled individual no later than 21 days of filing the petition in court. So what I typically explain is that you go get the second certificate first, particularly if you're going to have the second individual be a physician at Kennedy Krieger, because the wait list is pretty long there. That individual will go ahead and get the certificate done. Then while they are getting the certificate done, we're working with the client to get the petition drafted and make sure it's good to go, everything is accurate, and then go take the child to the physician who's going to do the exam. The second certificate can be either another physician, a psychiatrist, which is also another physician, or a psychologist, or a licensed clinical social worker, or a nurse practitioner. The courts have been very open to receiving a physician certificate and then the nurse practitioner in the same office, their certificate as well. So a lot of families that I help with guardianship opt for that because it's pretty easy to get those two certificates. But there's lots of options here regarding the medical personnel that have to provide those certificates. But again, the key here is that the individual doctor who's going to examine your child has to be within 21 days of us filing the petition. So we're really careful to make sure that that gets accomplished. Next slide. Once the guardianship petition is filed, then what needs to happen is that all the interested persons have to be served. Who are those interested persons? In a guardianship proceeding, if an individual is under the age of 65, then the Department of Social Services in the county has to be an interested person 100%. Then any siblings of the alleged disabled person is an interested person, whether they're minors or not. Then if the individual is receiving benefits from the Social Security Administration, then Social Security is also an interested person. If they're receiving medical assistance, Medicaid, the Department of Health, medical assistance is also an interested person. And if they're receiving benefits from the Developmental Disabilities Administration here in Maryland, DDA will also be an interested person. When the court issues, after receiving the petition and the certificates, they will issue a show cause order. The show cause order will be served along with the petition and the certificates on all the interested persons. They will also issue an order appointing a court-appointed counsel for the child. The court-appointed counsel will go out, will meet with your child. They will then determine whether or not the child needs a guardian and whether or not the information in the petition is accurate. They will file what's called an answer. The court-appointed counsel will then make a decision whether or not the child should be present for the hearing or whether they're going to waive their presence. The court-appointed counsel will also decide whether or not a jury trial should take place. Typically, particularly with transitioning youth and young adults, they will waive the attendance at trial, and they will also waive a jury trial. Burden of proof is clear by clear and convincing evidence, okay? That means that the judge has to be convinced that the evidence shows clearly that the need for a guardianship of the person and or property that the petitioners are asking for is necessary, that there is no lesser restrictive alternative for that particular alleged disabled. And then finally, the court has to then decide whether or not the individuals petitioning the court are the individuals that have the highest priority or are the most appropriate to be guardians of the alleged disabled. Once the court decides that the petition is to be granted and the individuals that are petitioning the court are going to be court-appointed guardians, the court will then make sure that you take training. There's an orientation training session, and then there's a after appointment training. That is an online-based training. It's in English and it's also in Spanish. Once you complete that training, then we have to file a certificate of compliance. After the hearing, the court will issue an order. The order will be showing who is the guardian, what rights they are able to participate in as guardians. For instance, if parents are typically if parents are appointed, they can make life-ending decisions for their child without having come back to court for permission. There are two things that you cannot do as a co-guardian or a guardian of the person. You cannot make the disabled individual have a voluntary admission to a mental facility. The court has to make that determination, so you cannot make that determination on your own. The second thing that a guardian cannot do on their own is sterilize the disabled individual. If there is a change of abode on the individual who's disabled, then the guardian has to notify the court and ask permission to change the abode. What does that mean? If you are saying, let's say they're living at your home. So for instance, when Abigail transitioned from the Maryland School for the Blind into adulthood, it was just our luck that, it was 2020. So she graduated and our transition plan was put on hold for a year. When we went to make that transition into her own home, I had to petition the court requesting the permission to do that, and it was granted the same day, but I still had to do that pursuant to the court order. The reason why this slide says circuit court in most cases is that there are cases where you need guardianship that is of a minor child. The orphans court is also concurrent jurisdiction in those cases. So that's why I mentioned it here in this slide. Next slide, please. So the rights of the adjudicated disabled individual. Adjudication of a disability for purposes of appointing a guardian in Maryland may not be the basis for the commitment to a mental institution. So I just mentioned that. It also does not modify any civil rights unless the court orders it. So in Maryland, if your child has a guardian, that child can still vote, for example. Next slide. So what are the guardian's responsibilities? They have to do the online training that I mentioned. There would be an annual report that is due for guardianship of the person. So a year after you get appointed, about a year, you're going to get a notice from the circuit court reminding you that your annual report is due to be filed. The annual report is due 60 days from the date that you were appointed. So for instance, I was appointed guardianship on July 31st. And then I know come around July 31st, August 1st or so, I'm going to get something from the court, and then I would have until September 30th to file my annual report. If you are appointed guardianship of the property, then there's going to be an inventory that is due within 60 days of you becoming the guardian, which is going to tell the court what are the assets that the disabled individual owns and what is the value as of the date of appointment. Then the year comes around, you would then owe to the court a annual fiduciary report, which basically is an accounting that starts with your inventory, then reports what assets were received during the reporting period, what income was received during the reporting period, what expenses and disbursements were made during the reporting period, and what the balance is that's going to carry over to the next year. This report has to balance to the penny. The court is very, very serious about their reports. If you fail to meet those deadlines, and if the fiduciary report is not balanced and is not sufficient in explanation of those type of reporting requirements in the report, the judge will issue an order called a show cause order and bring you in for a hearing so you can explain and answer any questions the court may have regarding your fiduciary report, or if you fail to file a report as guardian of the person and or property, why haven't you filed it? So when you're appointed guardian, it's very important to remember that these reports are very, very important. The other thing that's very important if you are appointed guardian is to make sure that if you move, or if the disabled person moves to another address, you must inform the court right away. If you live in Montgomery County and you're appointed in Montgomery County and you end up moving to Baltimore County, then there is a process that needs to take place to transfer the guardianship to Baltimore County, since you now live outside of Montgomery County. So the jurisdiction, or we call it the venue of the court, will shift from Montgomery County to Baltimore County if that's where you move to, or any other county. If you move out of state, I get this question a lot. If you move out of state, what happens to your guardianship? If the state that you are moving to is part of an interstate compact, then there is a distinct procedure that has to take place here in Maryland and also in the court system to the state that you are moving to. It's very well spelled out. It's certain steps. Both states in that compact follow the same rules. If you're moving to a state, and there's a handful that do not belong to the compact, such as Florida, then you have to file in Florida a completely new guardianship petition and process. Once you establish guardianship in Florida, then you have to come back to Maryland and terminate the guardianship in Maryland. So keep that in mind. Next slide. So, thought I'd end up my presentation with some practical tips. Plan early. Before your child turns 18, try to get updated assessments between 18, 21 years of age through your IEP team. Make sure that you're discussing in your IEP team meetings transition starting at the age of 14. So under federal law, they have to start talking about transition at 14. Now, the discussion at 14 is most likely going to be pretty high level. And as you progress towards 21, those discussions should become more hearty. They should be becoming more fact specific, and the plan needs to be very robust as you're getting closer to transition. Review, prepare, and update your estate planning documents. If your child is going to be receiving any means tested government benefits, meaning that there is a asset limit and or income limit to qualify, then you need to be considering whether or not you need to do special needs planning, which would include special needs trust. Develop a functional system to maintain records. This, I think, is a really good practical tip. The guardianship, for instance, the guardianship reports, and even when you have to report to the Social Security Administration, one of the things that I learned very quickly is in my guardianship report for Abigail, she goes to the doctors a lot, right? She goes to lots of specialists, a lot of doctors. And at the end of the year, the first year I had to go back on my calendar and figure out when did she go to the doctors, because I couldn't remember them all, because they're going to be very specific questions on that report. It's going to be, who did she see? When did she see the doctor? Who the doctor was? Why did you go? And then there's other specific things like the medication list, like what medicine is she taking? What's the dosage? How many times a day is it given? I became a lover of Excel. I started to put all the doctors, I'd go to the take her to the doctor, I'd come home that night, I'd go into the Excel spreadsheet, I type when they, we went today, this is who we saw, and this is the reason. If there's any medication changes, we have a running medication list for her. So those are some practical tips, because at the end of the year, when you have to report to the court, if you are appointed guardian, trying to remember when you went to the doctors, it's a long time in a year. Maintain, update a succession plan. As you get older, as an adult, and your children are getting older, this is going to become even more important. But even if you're young and you have a young adult child, think about who's going to come in and help you, or who's going to step into your shoes if something happens to you. We all worry about that. That is something as special needs parents, it's definitely very near dear to our minds. But if you plan and you have those hard decisions now, it brings some of the anxiety associated with it down. And a special needs planner is a good person to talk to, because we have lots of different type of connections within the community to help with succession planning, with any type of help. There's organizations out there that can help if you don't have a lot of family members that are local, or don't have a lot of family members that are able to assist. And I'd identify and utilize your resources is another helpful hint, tying into perhaps having discussions about what's important for your child and how do you want to approach those and meet those goals that you and your child may have for their adult life. Next slide. Okay, questions. Do we have any questions in the chat?
So this is Jen from DSNMC. If anyone does have a question, you are welcome to put it in the chat box. You could also raise your hand, and then if you'd like to speak your question, you could come off of mute to do that. I'm going to stop screen sharing right now, so that way in case people do want to come off camera, come off of their mute or on their camera.
Hi. Thank you for this presentation. I have two questions. Will the presentation be emailed to everyone who attends this evening?
I do not have an issue with that. I'm happy to share, have Jen share the presentation.
So I'm just,
Okay.
oh, sorry, just to respond to that too. I do know that the download of the recording does take a little while for us to get everything situated, and then we'll have it posted on the DSNMC website. So give us a moment for that. But I do know we'll be following up with you after the presentation as well.
Okay, great. Thank you. And my second question is, my brother who has Down syndrome, he and my parents used to live in the state of Maryland, but they moved to Florida in 2019. My parents still own a home in Maryland, but they don't reside there. They're just renting it out. So I did speak with someone down there who works at an organization for people with Down syndrome. And basically, since my brother lives in Florida, I live not in Maryland anymore. I live in Virginia. My parents do want me to be his guardian once they pass on, but I was told I'd have to live in the same state as my brother. So the plan is that if my parents pass away in Florida, one or both, I would move my brother back to the DC area and be his guardianship or guardian, I guess. That process gets to be a little tricky because my parents are not willing to relocate back at this time. And anyway, so in a situation like that where he lives in Florida, I'm going to be his guardian when they pass on or when they get to a point where they can't care for him anymore. But I live in Virginia.
Okay.
So aside from let's just say, pretend that I still lived in Maryland, hypothetically speaking, because I do have a sister who lives in Maryland. And so anyway, in a situation like that, what would you advise, or are you able to advise on something like that?
Sure, it's a great question. The order that's appointing your parents, you would have to probably file something in Virginia requesting a temporary guardianship be placed. And I can only speak to Maryland, but you'd have to get it. First of all, you have to get a lawyer in Virginia to help you. In Maryland, though, we would file a petition for temporary guardianship that gets pretty much quicker through the system to get a temporary guardianship in place and then go back to the permanent guardianship in place. Also, in Maryland, you could take if both your parents are deceased, it's kind of a tricky situation because there's really no one left on the guardianship order to have kind of filed here in Maryland temporarily, but you would file for a temporary situation. And I would represent in Maryland, I would argue that that's an emergency situation, given that there's no guardian appointed.
Okay, great. Thank you.
You're welcome. It's a great question. And I think my example with Florida, Maryland, I think the problem is that the state in itself, Florida, is not part of that compact. So that makes it a little bit more trickier, but the courts are here ultimately to make sure that the disabled individual is safe. So that's the argument I would be making, is that he's in another state. You're bringing them home. There's no guardian presently serving, to file a temporary guardianship case.
Okay, great. Thank you.
We have one in the chat. We moved from West Virginia to Maryland. Our daughter's 26 and has her guardianship in place for West Virginia since she turned 18. What's the process to change from West Virginia to Maryland? So I would have to look to see if West Virginia and Maryland are part of the compact. If the answer to that question is yes, then we file a petition in Maryland requesting to transfer the guardianship from West Virginia to Maryland. There would also be a petition filed in West Virginia with a West Virginia lawyer requesting the court to issue what's called a provisional order. The provisional order will then be filed in Maryland. Then Maryland will sometimes we'll put it in for a hearing. Sometimes they will just rule on the actual provisional order without a necessity of a hearing. It's at the court's discretion. But regardless, you would have to serve all the interested persons under Maryland law with that petition. A show cause order will be issued once the termination of the show cause period expires and there's been no one that has objected to the transfer of the guardianship. Then if they do not set it in for a hearing, they will go ahead and issue the order. Once the order accepting the provisional order is signed in Maryland, then you go back to your West Virginia lawyer. They actually file that court order with their court in West Virginia. And then the West Virginia will issue a final order transferring the guardianship to Maryland. That's how that process works if you're in the compact. If you're not in the compact, then, like I said earlier, you have to file in Maryland, starting all over again with the 2 certificates and the whole entire process we just went over. And then once you get guardianship of the person and or property here in Maryland, then you would have to file in Florida to terminate the guardianship in Florida. Question in the chat: if you are a single parent, does the non-custodial parent have say so about guardianship decisions? They would be served at the petition for guardianship, and if they have an objection, then they would file something in the proceeding prior to the show cause date order expiring, and then it would be, a hearing will be set in as usual, and then it would probably at that point, if they're filing an objection, it would be a contested guardianship hearing, and that would be a hearing that both sides would present their case, and the judge will determine based on the evidence, and it would be a full-fledged trial at that point.
We did have a question from Isaac. You can come up with one if you'd like to.
Sure. Thank you. And let me just first thank you for an outstanding presentation. It was very
helpful.
Thank you. Yes, ma'am. I have 2, maybe 3 questions.
Sure.
I live here in Howard County, and I believe I heard you say you live in Anne Arundel County. So my first question is, are you taking clients at this time? And I want to mention that because because I have a son who's turning 18 in May, and he's been treated at Kennedy Krieger. So I mean, like, his doctor there is aware, and his pediatrician is also aware. And I believe the 2 of them are, well, I don't believe, I know the 2 of them are willing to provide documentation when needed. So would those 2 suffice as being the professionals that are needed to provide statements?
Yes.
Okay. And the second part to that question is, you said guardianship was the most, I guess, complicated. So I'm assuming that is also the most expensive. I don't know how fees run, but are there discounted fees? Are there support? I mean, does your office take a look at that? Because I'm just trying to get prepared and make a budget for it. And I'm completely unaware because I haven't done this before.
No, absolutely. Great question. So the guardianship proceedings, they can run, they are expensive, more so than the other options, which don't really cost any money. I've been quoting a range, and let me explain why. Before the pandemic hit, it was pretty straightforward to get service on everybody. We have to follow what's called the Maryland rules as lawyers. There's specific rules that we have to follow. The service individuals is one of many rules. We either have to serve the individuals and all the interested persons either by certified mail, return receipt requested, which is those green cards you get, like on mail, or hire a process server. Since the pandemic, the certified mail return receipt requested, which is the cheaper version of serving people, has been very difficult. Either the green card doesn't come back, or the green card comes back and there's no signature, or the green card comes back and it says C19 and there's a signature, which is code for COVID-19, and the postal worker signed it. None of those are sufficient enough to prove that the individual was legally served. If those don't come back in time, we then have to file a motion in the circuit court requesting for them to reissue the show cause order, and we have to start over. That can become costly because we have to draft another motion, we have to draft another show cause order, then you have to go and you have to serve them all over again. The other option is to hire a process server, and although it can be a little bit more expensive, it's obviously more expensive than certified mail, it gets done. So it's a long-winded way of saying that I now am quoting anywhere between $2,800 and $5,000 as a quote to get a guardianship through. And you're on the 2,800 side if service goes pretty quickly. If we have to file motions that we're not expecting, or we have trouble serving people, and we have to then get it all redone, that takes time, and that gets it a little bit more on the outer limits of that quote.
Okay, and just speaking of serving, who exactly is going to be served? Since my son lives with me, and I'm also married, and my wife is his mother. So the three of us that are concerned parties all live in the same home.
So do you have any other children?
Yes, I have other children. Yes, ma'am.
Okay, so the interested persons under Maryland law for a guardianship proceeding is the alleged disabled. Then you have to name in your petition another adult that does not live with you if you live with your child that you're petitioning the court for guardianship. Then all his or her siblings have to be served, whether they're minors or not. Then the Department of Social Services in the county that you live in, so for you, it would be Department of Social Services for Howard County. If the child is receiving Social Security benefits, Social Security Administration. If they're receiving DDA benefits, the Department of Health through the Office of the Attorney General. And if they're receiving DDA, they're also receiving Medicaid, and then the Department of Health for medical assistance has to be served. Those are the required individuals, interested persons, so to speak, for that particular fact pattern.
Okay, all right. Thank you for that. And my last question, I promise this is the last one. You mentioned moving from state, which is completely understandable. But what about in the case, because I am military, we have to move out of country. How would that work?
Yeah, that becomes very complex. And first of all, thank you from the bottom of my heart for your service. We're a military family too, so I totally appreciate your sacrifices. So thank you. I would advise you to seek it to talk offline. I'll be happy to talk offline on that, just so you know that it's very complex, but it is doable. We typically work with a JAG as well to make sure that we're hitting all the requirements. But that's something I'd be happy to go over with you if you want to contact me offline. And if we have any wonderful military people in the audience, same thing. It's a lot to discuss during a presentation. That's all. We could have a whole separate presentation on that.
Perfect. Thank you.
You're welcome. Any other questions?
Victoria, would you be willing to put your contact information in the chat?
Sure.
And then also to all attendees right now, if there is another question, this would be a wonderful time to ask it. So once again, you can come off of mute, you can raise your hand, or you can type it into the chat. So we'll pause for just a moment here to see if there are any other questions. And if not, we will wrap up with a brief survey.
I have another quick question. Will there be another one of these sessions in the future?
Are you talking specifically regarding guardianship or just speakers in general?
Speaker in general.
Yeah, so right now, this is actually a partnership between the Down Syndrome Network of Montgomery County and the Down Syndrome Association of Maryland. And so we alternate months. but it's part of a larger series of parent and caregiver workshops. So those are posted on our website, which I'll add into the chat. So you can take a look and see ones that we have upcoming. And then also I'll put in the Down Syndrome Association of Maryland too, because you'd find similar information on their website.
Okay, thank you.
And then also, if everyone could please direct their attention to the chat, I did add in the Google form, which would be what we'd like you to fill out prior to leaving tonight, just with some feedback from the session. And then Victoria added her contact information as well. So if we could just see if there's any other questions. And then I'm also going to post our website. Victoria, do you have any closing remarks for us before we end this evening?
Thanks, Jen. Just thank you so much for allowing me to come speak with you guys. I'm very passionate about my work as I live it every day, and we're in it together. So I'm just really honored that you guys asked me to come speak to your group tonight. Any questions you have, I'm very open about answering questions. So just reach out to me, and I'm happy to help you in any way that I can.
Wonderful. Thank you so much, Victoria, for presenting to us tonight. We really appreciated it. Like I said, Victoria has put her contact information in the chat, and we've included a survey for you to fill out for feedback. You will be receiving a follow-up email from us. And just like I said, give us a little while to put the recording on our website, but it will be present ideally in a few weeks. So if you haven't seen it, feel free to message the info or admin addresses, and they can give you a timeline as to when that would show up. Everyone else, thank you so much for joining us tonight. You are welcome to fill out the survey and then head on out and enjoy your evenings.
Thank you, Jen.
Thank you.
Great.
Bye-bye.
Thank you.